Patenting 3D printing innovations in art and sculpture is a rapidly evolving and challenging area of intellectual property. Today, we're diving straight into how inventors and artists can protect their 3D printing innovations in the world of fine art and sculpture. 3D printing has revolutionized artistic creation, allowing for complex geometries and new mediums, but this blend of technology and creativity presents unique patenting hurdles. This area is particularly challenging for intellectual property law because it sits at the intersection of mechanical invention, which is patentable, and pure artistic expression, which is typically covered by copyright. The uniqueness of 3D printed art lies in its ability to realize forms previously impossible, often making the process itself a key part of the innovation. A major step is defining if the innovation is the artistic expression itself, or the functional aspects of the 3D printing process, or the resulting structure. 3D printing inherently blurs the lines, as the method of creation often dictates the aesthetic possibilities, making separation difficult in IP claims. To be patentable, 3D printing innovations in art must meet the core criteria: novelty, non-obviousness, and utility. For 3D art, novelty requires that the innovation hasn't been publicly known or used before, and non-obviousness means it wouldn't be readily apparent to someone skilled in the art. Utility and industrial applicability are usually easier to establish when the innovation relates to the functional aspects of the printing method or materials. Inventors need to strategically decide whether to protect the 3D printing process, the resulting artistic product, or both. Patenting the 3D printing method involves claiming the steps or parameters used to achieve a novel result, offering broad protection regardless of the specific final product. Patenting the resulting sculpture as a product claim protects the physical structure, materials, or internal geometry if these elements are novel and functional. Beyond utility patents, design patents and copyright offer additional layers of protection for the aesthetic features of 3D printed art. A design patent is ideal for protecting the non-functional, purely ornamental or aesthetic features of the 3D printed sculpture. Copyright automatically protects the original artistic expression embodied in the 3D printed art, particularly for purely aesthetic works. Let's consider a theoretical case study to illustrate these concepts in practice. Analyzing a relevant patent application shows the careful wording needed to claim a 3D printed structure based on its unique internal lattice, which provides both strength and aesthetic appeal. In conclusion, protecting 3D printed artistic innovations requires a hybrid approach, leveraging utility patents, design patents, and copyright. Inventors and artists should focus on the novel aspects of the printing method, the functional design, and the overall aesthetic to build a strong IP portfolio. We anticipate future IP trends will focus heavily on digital files, material science innovations specific to 3D printing, and increasingly complex functional aesthetic hybrid claims.